G'day everyone, welcome to Arjay's This Is Not Legal Advice, episode 8. So in this episode I will be going through a communication exchange between myself and the Hungarian embassy concerning would someone in Josh Frydenberg's circumstances be a Hungarian citizen. And this is using information that was available back in February 2018. Since then, things have gotten worse for Mr. Frydenberg. Anyway, so Szia, Josh, which is Hungarian for hello. Anyway, so I'll probably screen record the following, but as a basic summary, with the extra information that Mr. Frydenberg's provided to the Parliament, which perhaps he knew that information all along and therefore could well be guilty of fraud, obtaining financial advantage by deception, all this other stuff, contempt of Parliament, blah blah blah. But the extra information is that his mother was still a Hungarian citizen until 1948. It does not state, how she allegedly lost her Hungarian citizenship. And what I believe the argument would be is a ridiculous argument that the High Court has already heard and already said isn't sufficient. And that is back in the day, that people used to have to renounce their citizenship when they became an Australian citizen, in which case that didn't even apply in 1948, but we'll go through some screen recordings in a second, and I'll go through that. So let us begin. So I'll read out this email exchange between myself and the Hungarian embassy in London. Unfortunately, the video cut out when I changed windows, which is annoying. So now I have to do split screen and have little tiny writing that hopefully I can read. So the subject line is citizenship by descent, and I sent this on the 8th of February 2018 at 11:05 a.m. local time. It was sent to the Hungarian embassy at konz.lon for London at mfa.gov.hu. So I wrote, "Hi, in the following, would the child, a son born in 1971 in Australia, be a Hungarian citizen or entitled to any extra privileges over an Australian not in such a situation? Mother, a Hungarian Jew, born in 1943 in a Hungarian ghetto, travels to Australia at the end of World War II with her Hungarian Jewish parents, with a valid Hungarian passport. It is my understanding that Jews were stripped of their citizenship during the war, and that said citizenship was restored in 1993 as if the citizenship was never stripped. Also, that descendants of Hungarian Jews in the above situation are automatically Hungarian citizens since deprived of citizenship and forced to flee through no fault of their own. Thanks." And I have a reference JF just so I could find it easier for Josh Frydenberg. But that's not me saying I am Josh Frydenberg, of course. Anyway, so I received a reply on the very same day at 8:35 p.m. What great customer service they have at the Hungarian embassy in London. So it's from London Honasitias. How do you pronounce that? Maybe I'll look that up. That'll be fun. If I can highlight it. Honasitias. Show. Won't let me click on it to copy it and put it in translator and see how you're supposed to pronounce it. Anyway, So this came from honositas.lon at mfa.gov.hu. So honositas is HONOSITAS. And I'll try and copy that, even though it doesn't have the little marks for it. So naturalization. And it's pronounced honoshitas. Honoshitas. So going back to the email. So London honoshitas-lon. So as you'll see in this, it basically says that the citizenship is automatic and that someone in Josh Frydenberg's situation must be a Hungarian citizen. And I will just read from now, where it has email addresses, or not email addresses, but links. I will just, roughly go over them. There's quite a few there. So, dear customer, thank you for your inquiry. According to the circumstances you described, you must be a Hungarian citizen. It is need to be verified only. That is why you have to apply for a citizenship verification. For the verification of citizenship, you should apply in person and a prior appointment should be booked. Has an email address ifr.mfa.gov.hu. You have to provide your valid passport, your original birth and marriage certificates. Your spouse with her valid passport needs to attend on your appointment to sign the form of marriage registration in the presence of the consular administrator. Also, you need to obtain your Hungarian national ancestors' original birth and marriage certificates if they were not born in Hungary and their marriage was not solemnized in Hungary. The registry certificates regarding the relevant Hungarian registration events of the person and his/her ancestors shall be obtained ex officio. For the English language certificates of birth and marriage issued by the authorities of the UK, USA, Australia, South Africa, or New Zealand, Hungarian translations are not required. However, the certificates issued by an authority of a foreign country needs to be legalized with apostille, however you pronounce it, apostille I think it is from memory, or diplomatic legalization. You can find the members of Hague Conference here. Email address hcch.net/states/hcch-members. Please try to collect every document which can prove your ancestors' Hungarian citizenship, e.g. old passports, ID cards, school certificates, etc. Please find attached the application forms in English and in Hungarian. You have to fill in the Hungarian forms in advance. The English ones are for your help only, including the verification of your citizenship. We need to register your birth and marriage in the Hungarian system. So you need to fill in the application forms for it as well. For further information, please visit the website of the consulate and the website of the Immigration and Asylum Office on the links below. There are a couple of typos in here, but that's fair enough. So then it's got links, london.mfa.gov.hu/EGYSZERUSITAS-HONOSITAS-ALLAMPOLGARSAG. And there's another link, bmbah.hu/index blah blah blah. I'll skip reading through all of that. Once a Hungarian authority verify your Hungarian citizenship, you can apply for a Hungarian passport. Another link, london.mfa.gov.hu/englevelsl/igengYLESE-NAGYKNAK. Should you need any further information, please do not hesitate to contact me. Kind regards, Holbing Eva /Eva Hobling. Gonsulzuli, I won't pronounce the rest of the Hungarian, but it's got Hungarian then in English for these further parts. So whatever that is, however you pronounce it, is Consular Administrator, Embassy of Hungary, Consular Section. 35 Eaton Place, London, SW1X8BY. Telephone number is included, and fax number, and email or website address it should be. And then it's verified by V4 Connects, Hungarian Presidency, Viscard Group, something like that. So then, of course, there's also a bunch of attachments on there, as the lady stated, and I replied back, awesome, thank you, at 3:23 a.m. on February 9th, 2018. So after this, I'll just do screenshots or screen recording and a commentary on top of that. So here's an email I sent. You can see, the dates and whatever. Someone wishes to purchase a copy of this and an affidavit that it's a true email, then they can purchase that from me. See, you must be a Hungarian citizen. So they took it as if I was the person I was asking about, which I did not state, and that's why it says you as opposed to the person you describe. And some of the English isn't the best, but that's fine. I'm sure the lady can speak many different languages, and probably many more languages than I can speak. And even I make typos, of course. So there you go. So that's one gone. And I can move this over. Here's a greeting for Josh.
Szia.
Szia. Hello in Hungarian. So here's the Australian citizenship pledge. In the previous video to the one with me reading the contents of the email correspondence to and from the Hungarian embassy in London, then I think in that version that I mentioned about a possible argument Mr. Frydenberg might try and make, and that is that when his parents, or when his mother in particular, became an Australian citizen, that she was thereby renouncing her foreign citizenship of the Hungarian country, even though there was also that other document that claims that she was stateless, and then it turns out it was incorrect, that she had arrived in Australia on a valid and legal Hungarian passport. But this is the current Australian citizenship pledge, and I'll also go through more legal details in a few minutes, in regard to renouncing citizenship via becoming an Australian citizen. Like I said, I'm not sure if it was in the original video, because when I tried switching screens, then the webcam cuts off depending which program I use and what the computer feels like doing on the day. So this is Immigration and Home Affairs website. It says Australian Government, which really should be Government of the Commonwealth of Australia or whatever, but that's for another video. So, about citizenship ceremonies, Australian Citizenship Pledge. It says all Australian citizens should understand what it means to be a citizen. It is a critical part of building our nation. Most people make the Australian Citizenship Pledge at a citizenship ceremony. You might hear people call it the Pledge of Commitment. Making a pledge is a public commitment to Australia. It means that you are accepting the responsibilities and privileges of citizenship. If you learn the meaning behind the pledge, you will begin to understand what Australian citizenship means. You can choose between two versions of the pledge. One mentions God and one does not. Last updated 6th of September 2018. So, Pledge 1. So I'm losing my voice as well. From this time forward, under God, I pledge my loyalty to Australia and its people, whose democratic beliefs I share, whose rights and liberties I respect, and whose laws I will uphold and obey. Pledge version 2 just doesn't have under God in it, so there's not much point me repeating it. Next, this is Wikipedia about the different versions of the Pledge of Commitment for Citizenship. It was easier to use Wikipedia rather than going through, different pieces of legislation. Also on the legislation.gov.au website, the earliest version they have of the Naturalisation Act or Nationality and Citizenship Act 1948, Commonwealth, was from 1972, I think, from memory, and I couldn't be bothered looking up, old statute books or something like that. So this goes through that, the wording has changed over time. Australian nationality was created by the Nationality and Citizenship Act 1948, which came into effect on 26 January 1949. So even that is after when, Mr. Frydenberg's mum is purported to have lost her Hungarian citizenship. So before that, then we're all British subjects anyway, and British citizens, Australians, Canadians, New Zealanders, and UK people as well, and some other foreign lands or dependencies on the UK are still Commonwealth citizens, which is a little known fact. But anyway, so his mum, when she moved to Australia, might well have become a British citizen, so maybe even holds British citizenship, and same with his father, who came from Poland or was Polish. So skipping through this, they have the original version was I insert name, swear by Almighty God that I will be faithful and bear true allegiance to His Majesty King George VI, his heirs and successors according to law, and that I will faithfully observe the laws of Australia and fulfil my duties as an Australian citizen. Then in 1966, Harold Holt, he added a clause renouncing all other allegiance in the oath. So it also says that there was no requirement for new citizens to formally renounce their citizenship in their previous country or country of their previous citizenship. And then in 1973, it goes through the Whitlam government, ended the preferential treatment for British subjects on 1 December 1973, and inserted reference to Queen of Australia, as we know from TINLA episode 1, and also another episode that I'll eventually make one day that goes into heads of power, etc., that the title of Queen of Australia is an invalid title. And it's quite illegal, actually, which is one of many illegal things that Gough Whitlam did, including purported legislation that is invalid, that should be challenged for being constitutionally invalid. And as I said, you can look up at the end of this, Arjay's TINLA number 1, and that's on the Queen of Australia's title and why it's illegal, part 1 of 2, and part 2 is coming one day. So then that version was, I insert name, renouncing all other allegiance, swear by Almighty God that I will be faithful and bear true allegiance to Her Majesty Elizabeth II, Queen of Australia, her heirs and successors according to law, and that I will faithfully observe the laws of Australia and fulfil my duties as an Australian citizen. 1986, Bob Hawke, he removed the renunciation requirement and the requirement for candidates to state their names, so they don't even need to say their name anymore since 1986, which is a bit odd. But I swear by Almighty God that I will bear faithful... I swear by Almighty God that I will be faithful and bear true allegiance to Her Majesty Elizabeth II, Queen of Australia, her heirs and successors according to law, and that I will faithfully observe the laws of Australia and fulfil my duties as an Australian citizen. So then it changed again in 1994, and that means that since 1966, well, not since 1966, since 1973 until 1994, so that's 21 years, that people were swearing an invalid oath to a false-titled queen, even though, legal fictions can overcome such things, but that's another story. So in 1994, Paul Keating replaced the oath with the Pledge of Commitment, so it's no longer an oath, it's just a pledge, and removed the reference to the Crown, which again is very odd. So then it was changed to, from this time forward, under God being optional, I pledge my loyalty to Australia and its people, whose democratic beliefs I share, whose rights and liberties I respect, and whose laws I will uphold and obey. And there's been no changes since. Just make sure nothing private's showing there. I don't think so. So, if the claim is that previous citizenship has been renounced by taking up Australian citizenship, even though they weren't Australian citizens until 1949, which is the year after Josh Frydenberg's parents came to Australia, then we've got Sykes and Cleary. This is from 1992. This is usually used as a case about officers of profit under the Crown. So Mr. Cleary, there were a number of potential ineligibilities to him being in Parliament, one of which was that he was a school teacher on leave without pay, and then he was still deemed to be holding an office of profit under the Crown, and I think that that is a correct interpretation of the High Court. And it also clarified that even though he was a state employee of the Crown, that he was banned from federal Parliament. So he was also purported to be a British citizen and some other interesting things, which is a discussion for another video. But there were also two other people who were having their eligibility challenged in regard to that particular election, and they were covered by this court case, and it introduced the reasonable steps test, which has continued today, including in re Gallagher, where Labor was lying and claiming that a new test was made by the High Court about reasonable steps, which is false anyway. So first of all, we've got the judgments of the Chief Justice Anthony Mason. We've got Toohey and McHugh, justices all concurring, or their joint judgment. Who knows who actually wrote it? So the second respondent was Mr. Delacrezas, however you pronounce that, Taz. He was born in Switzerland. I may as well go through these and may as well read them now, even though the video is going to be a bit long. But that's fine. You can skip ahead or put it in 2 times speed, whatever. So there was a Swiss man named Mr. Delacretas, and there was also a Greek man, Mr. Karamitsis, I should say. And I'll have 29 different spots where it says oath, and I'll just read those paragraphs, I guess, or summarize them. So with Mr. Delacretas, I'll just call him second respondent in case it doesn't have his name again later for me to try and remind myself. He went to Australia in 1951. He was born a Swiss citizen. And on the 20th of April 1960, he became naturalised as an Australian citizen pursuant to Division 3 of Part 3 of the Nationality and Citizenship Act 1948 Commonwealth. And in doing so, he renounced all allegiance to any sovereign or state of whom or of which he was a subject or citizen, and took an oath of allegiance to Queen Elizabeth II, and that includes to be faithful and bear true allegiance to Her Majesty, ... her heirs and successors, and to faithfully observe the laws of Australia and fulfil his duties as an Australian citizen. And quoting a little bit, however, he did not at any time make application to the government of Switzerland to renounce or otherwise terminate his Swiss citizenship. He has held an Australian passport since 1960, and it is still current. He holds no other passport. Under the law of Switzerland, a Swiss citizen will be released from his or her citizenship upon his or her demand if he or she has no residence in Switzerland and has acquired another nationality. The second respondent has made no such demand and is and was at all material times under the law of Switzerland a Swiss citizen and entitled to a Swiss passport to enter Switzerland without restriction and to reside in that country, i.e. he was a Swiss citizen and ineligible for Parliament. And within this judgment, it also later goes on about the so-called reasonable steps test, and that includes that basically the exception to that is that if a country is on purpose making it so someone cannot renounce their citizenship and has special circumstances for that instead of the general law of that country on how to renounce a citizenship, then the court might accept that the person is no longer a citizen even though they are. So it goes from the law of the country. And of course, Josh Frydenberg is trained as a lawyer, and he darn well knows that he should have checked his citizenship and should have renounced his Hungarian citizenship. Anyway, so the third respondent, Mr. Karamitsis, born in Greece, 1952. He was a Greek citizen, came in 1969 as a migrant sponsored by his brother and lived in Australia ever since. On 12 March 1975, he became an Australian citizen pursuant to Division 2 of Part 3 of the Australian Citizenship Act 1948, Commonwealth. In doing so, he renounced all other allegiance and swore the oath of allegiance in a form similar to, but not identical with, that sworn by the second respondent, the Swiss citizen, that is. He did not at any time make application to the government of Greece to discharge his Greek nationality, and when he became an Australian citizen, he surrendered his Greek passport. It had expired 1 or 2 years after he migrated to Australia. So, skipping ahead, he didn't leave Australia. He had an Australian passport since 1978, and another one in 1987. He entered Greece on an Australian passport for a holiday in 1978, 1987, and for a funeral of his mum in 1979 and his father in 1990. He's never received any social security or benefits that are similar to that from the government of Greece. He never stood for office in Greece or voted or been recorded as a voter in an election in Greece. He has not, to any of his knowledge, done any acts that would, acknowledge allegiance, obedience, or adherence to Greece or any other foreign power. When he took Australian citizenship, he took a conscious and serious step which he believed invoked breaking his bond of allegiance with Greece and establishing a new bond of allegiance with Australia, as stated with the oath that people had to swear back then. He's lived in Australia, participated in Australian public life, blah blah blah. Under the law of Greece, a Greek national will have his or her Greek nationality discharged if A, he or she has acquired the nationality of another country with the permission of the appropriate Greek minister. B, he or she has acquired the nationality of another country and later obtains the approval of the Greek minister for the discharge of his or her Greek nationality. In the latter case, the discharge of the Greek nationality becomes effective as from the date of the Greek minister's approval, not from the date of acquisition of the foreign nationality. And he is not sought to be discharged by the minister, and then I'll quote, and accordingly, under the law of Greece, he is and was at all material times a Greek national. As a result, he is and was at all material times entitled to apply for a Greek passport and using that passport to enter Greece and stay in Greece without time restrictions and without permission. So then it also says that he swore allegiance to Australia multiple times when he was elected councillor and when he was appointed a Justice of the Peace, but it doesn't really matter. And I'll just quickly go through other people's judgments. So this is now the judgment of... No, still the same one, sorry. What is this doing? What am I doing? One of the two. So anyway, skipping ahead, we've also got judgments of other judges in the same case that basically say the same thing. So there's Justice Dean, and he did renouncing all other allegiances. This is the third respondent again, and blah 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 blah. See if it's got something more interesting. Not really, but I can see quickly. So what's his conclusion? So then Justice Dawson, no, skip that. Justice Gaudron. So it repeats about renouncing all other allegiances with the oath, and basically it's not good enough. So, you can read this case in your own time if you want. It won't really make it an interesting video if I read the whole case. Announced. There's an interesting little part that I'm looking for if it comes under oath. This is kind of interesting as well. So this is about the second respondent. So unless things are approached this way, the oath and affirmation required by the Citizenship Act in 1975, indeed from 1966 to 1986, and which operate to confer Australian citizenship, was to the extent that it involved renunciation of all other allegiance, is but an empty gesture. Maybe there's a bit of dissent there, maybe not. So anyway, I'll go right to the end. Hopefully it's got a conclusion. Just quickly type reasonable steps and see what comes up. Reasonable steps. I don't even spell at the moment, but that's okay. So this says, but there is no reason why section 44 subsection 1 should be read as if it were intended to give unqualified effect to the rule of international law. To do so might well result in a disqualification of Australian citizens on whom there was imposed involuntarily by operation of foreign law a continuing foreign nationality, notwithstanding that they had taken reasonable steps to renounce that foreign nationality. It would be wrong to interpret the constitutional provision in such a way as to disbar an Australian citizen who had taken all reasonable steps, so have to take all reasonable steps, to divest himself or herself of any conflicting allegiance. It has been said that the provision was designed to ensure, and then a quote within this quote, that members of Parliament did not have a split allegiance and were not, as far as possible, subject to any improper influence from foreign governments, unquote. What is more, section 44 subsection 1 finds its place in a constitution which was enacted at a time like the present when a high proportion of Australians, though born overseas, had adopted this country as their home. In that setting, it could scarcely have been intended to disqualify an Australian citizen for election to Parliament on account of his or her continuing to possess a foreign nationality, notwithstanding that he or she had taken reasonable steps to renounce the nationality. In this respect, I'm going to keep reading on. So, ... What amounts to the taking of reasonable steps to renounce foreign nationality must depend upon the circumstances of the particular case. What is reasonable will turn on the situation of the individual, the requirements of the foreign law, and the extent of the connection between the individual and a foreign state of which he or she is alleged to be a subject or citizen. And it is relevant to bear in mind that a person who has participated in an Australian naturalisation ceremony in which he or she has expressly renounced his or her foreign allegiance may well believe that by becoming an Australian citizen, he or she has effectively renounced any foreign nationality. And then it's got application to the second respondent and the third respondent. So with the second respondent, it says, the second respondent, the Swiss man, omitted to make a demand for release from Swiss citizenship, which would have been granted automatically as he has no residence in Switzerland and has been an Australian citizen for 32 years. Because he has failed to make such a demand, it cannot be said that he has taken reasonable steps to divest himself of Swiss citizenship and the rights and privileges of such a citizen. Application to the third respondent. The third respondent has omitted to seek the approval of the appropriate Greek minister for the discharge of the Greek nationality. Whether the grant of that approval is a matter of discretion or is automatic is not altogether clear. Presumably it is the former. So that relates to when they make an application, are they automatically granted that right to renounce their citizenship, or is it by discretion? So continuing, but in the absence of an application for the exercise of the discretion in favour of releasing the third respondent from his Greek citizenship, it cannot be said that he has taken reasonable steps to divest himself of Greek citizenship and the rights and privileges of such a citizen. And then just checking for anything else that's interesting instead of just repetition. And I still have a few other things to... Here we go. Maybe this is important. So is a good place to start. So again, about renouncing foreign citizenship. So long as that duty remains under the foreign law, its enforcement, perhaps extending to foreign military service, is a threatened impediment to the giving of unqualified allegiance to Australia. It is only after all reasonable steps have been taken under the relevant foreign law to renounce the status, rights and privileges carrying the duty of allegiance or obedience, and to obtain a release from that duty, that it is possible to say that the purpose of section 44 subsection 1 would not be fulfilled by recognition of the foreign law. So, I'll do a video one day on Sam Dastyari. That'll be interesting. And then also not only Iranian citizens, but Greek citizens as an example. From memory, they also have compulsory military service for males, and i.e., are ineligible for Parliament unless they fulfil that duty. And it's not been imposed on them as individuals that they have to do it only because they are trying to be kept out of a foreign parliament, being the Australian Parliament, but it applies to all of their citizens. And must be stressed. So I'd quickly look up Sykes v. Cleary on Wikipedia, see if it says anything interesting that I've missed in this video without going through the whole judgment and without trying to be too boring. So facts, offers of profit. So Justice Dean dissented on the offers of profit part, and Dean and Gaudron dissented, but the majority of the court said what the law was, and that's what the law currently is. That you have these reasonable steps, and Gaudron too. That's just splitting up what Dean said and what Gaudron said. And anyway, so next we have the Citizenship Register, and this is from the former Parliament. So it says about this Citizenship Register. On 4 December 2017, the House agreeing to a resolution requiring each member to provide statement in relation to citizenship to the Registrar of the member's interests. The statement is to include the members' declarations as to Australian and foreign citizenship, relevant considerations and evidence. And you can look up this resolution. Probably just skip through it to make the video a bit shorter. But as it says there, false statements or omissions regarded as contempt. Any member who knowingly fails to provide the statement required or knowingly fails to correct an inaccuracy in his or her statement within the required time frame, which, as you'll see, will apply to Josh Frydenberg. And C, knowingly provides false or misleading information to the Registrar of Members' Interests, which might or might not include Josh Frydenberg, depending when he's supposedly found out about his mother's citizenship, that she was Hungarian allegedly until 1948, shall be guilty of serious contempt of Parliament and shall be dealt with by the House accordingly. That's a big joke because both sides of Parliament have people that do dodgy things, so they never get dealt with unless there's a big public outcry. And this will be shown later on with what they've done this year to make problems worse. But anyway, so he submitted on the 5th of December 2017 to the Citizenship Register. There's Joshua Anthony Frydenberg from Kuyon, born in Melbourne 1971, citizenship held at birth Australian, should really say, and Hungarian, and possibly other ones as well. Then it's got his mother and father's and grandparents' details, and his spouse as well. He claims, quote, I have retrieved documentation regarding the citizenship of my parents and grandparents from available family sources. Searches have been made of archival material available in Australia regarding my parents' and grandparents' citizenship. I have sought and received Hungarian legal advice from Hungarian citizenship law experts. I have sought and received Polish legal advice from Polish citizenship legal experts. I have sought and received Australian legal advice. And why didn't he just, seek and receive advice from the Hungarian embassy or consulate, as I have, for someone in his situation, and they say that he must be a Hungarian citizen? So I think, even though, presumably, I imagine that he did actually contact them, and if that was the case, then perhaps he's seeking legal advice from Hungarian citizenship law experts and, possibly Polish ones as well. And the Australian legal advice might not be legally privileged, because if it was known that he was a citizen of Hungary and the advice was seeking advice how to, get around his disqualification, and it's a constitutional disqualification, not even just a normal law, but constitutional law, then that's not privileged legal advice. Anyway, foreign citizenship. Have you ever been a citizen of any country other than Australia? No. So that appears to be false and serious contempt of Parliament. Foreign citizenship at time of nomination, he claims no, which again is another instance where it could be said reasonably on the face of it that he provided false information, which is fraudulent and also, serious contempt of Parliament. Foreign citizenship now, he claims no, again, same thing. And then his signature is redacted, but it's dated 4/12/2017. I don't know why they bothered redacting his signature because they don't do it later on. So then there's this other one, which is the Register of Members Qualifications for the 46th Parliament. So then it waffles on about on the 4th of April 2019, the House agreed to a resolution requiring each member to provide a statement in relation to their qualifications under sections 44 and 45 of the Constitution to the Registrar of Members' interests. In the statement, the member must attest to the accuracy and completeness of the material provided to the Australian Electoral Commission, AEC, in respect of the member's last nomination for election. So all the candidates for the election had to fill out these forms, and let's see what is put and what's changed and why those changes aren't reflected in this previous document, if this document should be updated rather than just replaced by this new one. So received 31st of July 2019, Joshua Anthony Frydenberg. For some reason the font's different colour there. So blah blah blah, his signature's redacted again, but later on I think it's visible. So this is an AEC qualification checklist. I'll just skip through. So it's got his mother and father and grandparents, their dates of birth, etc. It would be funny if it turned out that one of the date of birth was changed or something just to obscure searches or something like that. Presumably he didn't do that, so that's helpful. So mother, maternal, paternal. Where does it say his father? That's interesting. See, mother, maternal grandmother, maternal grandfather, paternal grandmother, paternal grandfather, but no father. So that's another interesting thing. So maybe something happened with his father that... No, his father was born in Australia. That's probably why then. Or is he? Yeah, so that's why his father will be not there. Anyway, just trying to quickly go through things. And this is not legal advice. It's about his father. It's claimed his father had Polish citizenship until 1948. But his father was born in 1942 in Melbourne. So unless he was just living here as Polish, and that seems very odd as well. But anyway, so then they've got his mother, 1943 until 1948. The story that was sold to the public in relation to Mr. Frydenberg's family fleeing Poland was that his mum fled Poland at the end of World War II, not years afterwards when there was already peace and already, safety and whatever else you want to call it, for the Jewish people, including his mother. but that's not how I recall it was told on the news. That his mum was born in a ghetto in Hungary, and she had to flee for her life along with her parents. Anyway, so Mr. Frydenberg doesn't bother putting that he's Hungarian, and also a problem that he would have is if he declared that he was a Hungarian, then i.e. try to I'll restate that. If he there you go, there's signature. So if Josh Frydenberg did the proper thing, which he should have done, which was never be in Parliament to begin with, or failing that, to renounce his citizenship before he even ran for office, and months in advance, because some of these things under standard procedures take weeks or months, such as renouncing UK citizenship as an example. But anyway, if he then found out during the previous Parliament that he was a foreign citizen, then he could have renounced his citizenship and had a by-election, or in the meantime, since he got away with being a foreign citizen on the face of it, then before this current election, the 2019 one, then he could have renounced his Hungarian citizenship. But because someone bothered to put in an electoral petition and challenge his citizenship, then that didn't work out so far. Because if no one put in an electoral petition, then he would get off so-called scot-free for being an ineligible parliamentarian. But someone did put in an electoral petition, so the only thing he could have done to counter that would have been to renounce his citizenship before that, but he would be then identifying himself as ineligible. But anyway, so what can you do about this? So I do have a fundraiser. This is the second fundraiser for similar things. So I guess I'll put a little privacy screen to cover the donor's name or something like that. So there was a previous fundraiser that raised about $600, including GoFundMe and non-GoFundMe sources, minus fees paid to PayPal and to GoFundMe. This money is being held in a constructive trust, of course. It can only be spent on legal costs, that kind of thing. That's stated in this GoFundMe campaign. So it's got challenge invalid laws, and I stuck a picture on there, which was a screenshot of one of the original annotated constitutions of the Australian Commonwealth, also called the Constitutional Commentaries by Quick and Garin. And anyway, so got some updates there, thanks to the sole donor, and it should have information. Here we go, we have to click read more. So originally I think had $90,000 goal, or $95,000 goal maybe, but then lady suggested that I reduce the goal to $30,000, which for some reason hasn't worked, because it still says $95,000, and do it in stages. And as it says, this is for fundraising for challenging the validity of certain provisions and acts that are or may be invalid. This may include any combination of the following and or others, and this includes about the Commonwealth Electoral Act 1918, Commonwealth. I don't think you can italicise maybe on this website, or maybe I should have italicised the names of the acts, but who really cares? So with the Commonwealth Electoral Act, the purported time limits for filing electoral petitions, the geographical restrictions in doing so, discriminatory provisions against independent and small party candidates, etc. The Royal Styles and Titles Act of 1973, which purported to change the Queen's style and title to the fake Queen of Australia designation, as per TINLA episode 1, which is half of the reason why it's not valid. As I said before, I'll make another video on other reasons, including the lack of head of power to make such law. Privy Council Limitation of Appeals Act 1968, Privy Council Appeals from the High Court Act 1975, the Australia Act 1986, Common Informers Parliamentary Disqualification Act 1977, also, if possible, to overturn certain cases, if possible twice, so we can edit that one day. Or their effect, e.g. concerning electoral petitions, parliamentary ineligibilities, claim that the UK is a foreign power, about the lack of jurisdiction of the High Court outside of electoral petition periods, that the High Court claims it doesn't have jurisdiction, maybe get a mandamus from the UK against the High Court if the High Court ignores the law and refuses filings again. As you'll be aware, in previous TINLA videos, I had made a filing with the High Court of Australia, including via the Common Informers Act and other legislation, to oust ineligible parliamentarians, and that was made on the 20th of April 20th of April 2018 originally. And the High Court refused to accept the filing, even though that is literally illegal, and then some other issues occurred with that. Anyway, with this fundraising, as it says, transparency is important. Keep getting little ads, which I'll probably have to have a blackout box. Little email notifications keep popping up. I can't get rid of them, which is annoying when I'm trying to screen record. Anyway, so transparency is important. So, when I raise this money and eventually get a court case in, which, might well take till June next year. I was trying to do it a lot quicker for a particular reason, with the electoral petition period being advertised incorrectly, both in the media and in government websites, timetables, that kind of thing. So that's why I was trying to get it in originally with the normal electoral petition period, and then the writs were returned a week early, and then I was still trying to get it in the period where the electoral writs were supposed to be returned and were advertised as being returned, and then that didn't work out. It would be helpful if people donated and shared the donation link, the fundraising, information, that kind of thing. And anyway, so then there's got some other disturbing things. So this is 10 News Daily, entitled "Grubby Deal Protects Criminal Bankrupt MPs Being Kicked Out of Parliament." And there are a number of bankrupt MPs and senators still currently in Parliament on the face of it. So Hugh Remington, National Affairs editor. So I'm not, messing up their copyright or whatever, even though there are lawful justifications to get around copyright. But I'll just summarise. So the Labor Party and Coalition, and it'll probably include the Greens as well, so really you can say the Labor Coalition and the Liberal Coalition, they changed the law. It's actually not even real law, it's policies and procedures of the Parliament via a motion or resolution, to make it that it is basically impossible to get ineligible parliamentarians dealt with by the High Court. This includes let's go up a little bit. Hopefully it's got in a summary. So it also includes apparently that all a parliamentarian has to do is declare something, and simply by doing that, that prevents the Parliament from referring them to the High Court, Andrew Wilkie said, who of course is an independent member in Tasmania. He claims there's no oversight, which of course there isn't oversight. And anyway, so then Professor Williams, who's George Williams, is purported to be, along with Anne Toomey, the two foremost constitutional law experts in Australia. But he said Parliament should be doing everything it can to make sure people are properly entitled to be in those chambers, and I completely agree. And then it goes on that Matthias Cormann claimed that timely disclosure will under no circumstance immunise a potentially disqualified parliamentarian from being referred to the High Court. It's a total misreading of the relevant resolutions. If a person becomes bankrupt or is convicted of a crime, blah, blah, blah. But then, as Hugh Remington says, but that's not what the new rules say. You can read them here and here. So you can read the motion on the parliamentary website. Motion details, how poll works. I'm surprised it's not just Hansard. But anyway, and then Senate debates on Open Australia. And then they've actually got the resolution here from 4th of April 2019. And it goes on. People can read this in their own time. It also says about false statements or omissions regarded as contempt as per the previous resolution. And, it appears that Josh Frydenberg is putting serious contempt or being seriously contemptuous, whatever, of Parliament. So, to Mr. Frydenberg, just wait, I've got to get the pronunciation. Bucho. Bucho. Goodbye in Hungarian. Mr. Frydenberg. Bucho. Okay, so thanks for your time. I know this video is probably not the most exciting one to watch, being screenshots and screen recordings with commentary over it for most of it, but the information contained within is very good information. And please like, share, subscribe, click the notification bell on YouTube, and post this to everyone. We shouldn't have ineligible parliamentarians in Parliament. Mr. Frydenberg, on the face of it, is ineligible for many, many reasons, which I've already provided to the High Court. That includes about his Hungarian citizenship, and the High Court refused to accept the filing, which is illegal. And I can prove it's illegal, but that's another story. If Josh Frydenberg wants to try and sue me for defamation or something like that over this video, then good on him. One, it's my opinion. Two, it is not legal advice. Three, I'm correct. Four, we get this little thing called discovery, and it also gives me the ability to adduce other reasons why he's ineligible. And that is assuming that he's found to be eligible by the High Court for having special privileges, which no one else has. As I keep saying, he's qualified as a lawyer. He's also a parliamentarian. He's well aware of the requirements to be in Parliament, of the existence of the Constitution, even if he's never actually read the Constitution, and which presumably he has. He would have had to have studied constitutional law as a part of his law degree, as part of the priestly 11 compulsory law subjects, and he should be banned from Parliament forever, and he should really be convicted, jailed if necessary, or whatever, and you have these things as specific and general deterrents if it is found that he is a Hungarian citizen and that he knew or ought to have known that that was the case. If I could find it more than a year and a half ago, and just being a layperson, then surely he knew about it, and he of course knew his own family situation. It's not like his parents are from very uneducated backgrounds or whatever. From memory, his mother is a high up professor at one of the universities, and he went through private Jewish what would you call that, religious school or whatever, that I'm sure costs a lot of money. So it's not like he lacked the resources or the nous, or his parents lacked resources or the nous to find out this information before he ran for Parliament. And anyway, thank you. And bonjour to Josh.